She was convicted of murder during the perpetration of a felony, and she was convicted of especially aggravated robbery. She was sentenced to a life sentence for the murder charge, concurrent with a 16-year sentence for the especially aggravated robbery. Total effective sentence of life. Your Honors, I raise, I believe, 8 issues in the appellate brief. I'm going to narrow the focus for the purposes of this hearing unless there are specific questions about issues that I don't intend to raise to address orally today. I do intend to address the speedy trial issue. I intend to address the issue of lost evidence, which is the 3rd section of the brief. Bias, I intend to address another section, I believe is the 4th section of the brief, regarding bias of one of the key witnesses in the case, Travis Wilkerson. The defense was not allowed at trial to introduce evidence that he was coming back to court the following week. And I intend to address the trial court's admission of repeated references to the actual victim, in this case, to his status as a disabled veteran. The remaining issues regarding lay opinion testimony, and a pellet gun, and uniformed recruits being allowed in the courtroom, I don't intend to address those issues today. But I'll be happy to address any questions that the court has on those issues. Your Honor, first with respect to the speedy trial issue, the argument, I think, is laid out relatively clearly in the brief. However, I want to address the way the state addresses its issue in their reply. In the reply brief, the state essentially, if I read them correctly, seems to suggest that because the defendant did not assert her speedy trial right early in the process, that she essentially waived that right going forward in the process. Ms. Moore was arrested in June of 2019. The parties agreed to a trial date in December of 2021. So by that time, already 2.5 years had passed. And those 2.5 years passed without the defendant asserting her right to a speedy trial. That's certainly true. The demand for a speedy trial was filed 3 weeks after that court setting where the initial trial date was agreed. The trial was set for 9 months from the date, from that date, which would have been September of 2022. The state then requested a continuance in August of 2022, just about a month before the first trial date that the parties had picked. We were then given a second trial date. The second trial date would have been in October of 2022. So we were set initially for trial September, then the trial was pushed back just about 3 weeks for the second trial setting. During that conversation, when the state was requesting its continuance in August of the September trial date to October, there were issues about, well, is everybody going to be able to be present for this trial? Are witnesses going to be able to be present? Because that's a fall break for the schools. The attorney who represented the state at trial was present in the courtroom on that day and made no mention of the fact that he wouldn't be available because he had a long planned vacation for that trial setting. Because the state failed to disclose their scheduling conflict for the second trial date that we had picked after filing a speedy trial motion, then the trial ended up being pushed off an additional 5 months to March of 2023. So even if you just start with the filing of the speedy trial request in September of 2022, apologize, in December of 2021, it's a 15-month delay between the filing of the speedy trial motion and the actual trial getting underway, which is sufficient to trigger a speedy trial analysis, even if she had not been if Ms. Moore had not been in custody for 2.5 years prior to the filing of the speedy trial motion. So the delay is very long. The reason for the delay, given what I've discussed about the prosecutor failing to disclose his own scheduling conflict, is at the very least bureaucratic indifference. I would suggest that there's some evidence that it was an intentional delay. The state wanted both of Ms. Moore's co-defendants to testify at trial. They wanted Gerard Williams to testify, and they wanted Travis Wilkerson to testify. Gerard Williams, for years, was unavailable to testify because he was in federal custody awaiting competency training for another matter. The state, on the record, said that its concern was getting Gerard Williams to trial. That's why they wanted to delay the trial. And when the court said, well, we can't just delay Ms. Moore's trial indefinitely because Mr. Williams isn't available until maybe he becomes competent, the state's response to that was that was a dilemma for Ms. Moore. That was a problem for Ms. Moore. It wasn't a problem for Ms. Moore. It was a problem for the state, and they were trying to do everything that they could to push the trial date back until hopefully Gerard Williams would be able to testify as well. So there's some evidence of intent. There's a very long delay, and the defendant absolutely did assert her right. The state's brief contends that the assertion of the right is a weak assertion of the right because it was asserted 2.5 years into her incarceration, maybe even a little bit later than that.
The pandemic kind of messed with it too.
Pardon?
The pandemic, COVID.
Because
there weren't any trials at all in Shelby County for a long time.
But when we first requested a trial date, the pandemic closures had concluded. Now, we were pushed to the end of a long set of cases that were already set for trial. That's why it was 10 months out from when we made our request. But none of the delay after we requested our trial date was directly due to the pandemic, except due to, I guess you could say, due to a backlog of cases set for trial at that time. Although the backlog of cases set for trial is pretty similar to that at all times in Shelby County, in a lot of courtrooms. The prejudice factor obviously is not the strongest in Ms. Moore's case. There was one witness who passed. I don't believe that his testimony would have substantially affected the trial. However, Ms. Moore testified at trial. And case law does acknowledge the fact that anxiety and concern of the accused and impairment of the defense constitute prejudice. In this case, her anxiety, she was very anxious. She was very concerned. Her trial was getting pushed back and back after she'd already been in jail for years. She was unable to have almost any contact with her family. She had children, and she saw her life slipping away from her, and her anxiety and concern caused impairment to her defense because when she got up and testified, she was in no mental state to testify.
Do you have any other evidence? I'm sorry. Do you have any other evidence of prejudice or any other examples that were alleged below?
I do not. Okay. No. However, I would also note that U.S. v. Bergfeld, B-E-R-G-F-E-L-D, it's a federal case. I think it's 280 Federal 3rd 490. Prejudice states that prejudice should be presumed when the other factors weigh heavily in favor of dismissal. for failure to provide a speedy trial. With respect to the lost evidence issue, there were two critical pieces of evidence that were lost by the state, by the, either by the investigators or in the transfer of evidence from the investigators to the attorney generals. There were two critical pieces of evidence lost. One was, I don't know how you could imagine a more critical piece of evidence to this case. It was a recording of Ms. Moore's co-defendant's initial police interview, Travis Wilkerson. It was an audio recording. Now, the trial court states in its opinion, finding that there was no, that it did not need to issue an instruction regarding lost evidence. The trial court said, well, you haven't even proved that the evidence existed. The detective who wrote the report referring to the recording, the audio recording of Mr. Wilkerson's initial police interview, herself said that the evidence existed. She went back and forth, her testimony was equivocal, but when you look at it closely, it is hard to imagine how she could be possibly saying that I didn't write in my report that we made a recording of what Mr. Wilkerson told us. She said when she was asked what the statement in her report meant, she interpreted her report to mean that me and my partner actually did make a recording of our conversation with Mr. Wilkerson. She said that her partner had an audio recorder at that time and that the report referred to her partner making the recording. The detective testified in that same hearing that the written statement that they got from Mr. Wilkerson was a transcript of Mr. Wilkerson's statement. It probably was made by someone listening to a recording and typing it out. It probably was, because it is lengthy, it's detailed, and it's included in the record, and it is in the voice of Mr. Wilkerson. The tone and the words, the lexicon that he uses in that statement are very similar to his testimony in the trial. They're not similar to the detectives. Now, the state will say, well, if you got a transcript of it, then you have comparable evidence to use. You could have impeached him from the transcript. I couldn't impeach him from the transcript.
Why not?
Because he denied that the transcript was authentic. He said, these detectives went in the back, they came back with a printout of my statement, and they said, here, sign this. They told him, sign it, you can't look at it, just sign it. Prevented me almost completely at trial from impeaching him with his written statement. He denied the authenticity of the statement. The other issue is the state will say, well, it's a transcript. If it is a transcript, then the recording existed. Then the judge is completely wrong. And if it's a transcript, we need a copy of the audio that the transcript was based on, because this wasn't prepared by a court reporter who knows when something's inaudible, you type inaudible. I've had transcripts typed up by staff at offices. They aren't accurate. There's a reason that we have trained court reporters in the courtroom. If it's a transcript from an audio recording, then the audio recording existed, and the defense absolutely should have had that audio recording of the co-defendant's initial statement to the police. It's hard to imagine a more material piece of evidence. And if it's not a recording, then it's even more inaccurate, because it was just someone sitting there typing, a police officer sitting there trying to type along.
I'm just finding it difficult, counsel, to see what the procedure would be, Because typically, if a witness is impeached by a prior statement, they get an opportunity to admit or deny making the statement, and then counsel confronts them with this specific statement, which I assume you said you did.
I tried.
Okay. And the jury hears that, but unless it's prior testimony or testimony under oath, how would a recording be admitted?
The recording would have been a prior inconsistent statement that he wouldn't have been able to deny because it would have been his.
Inconsistent statement?
Yes.
So it would not be admitted as substantive evidence?
I believe that rule, whether it would have been admitted as substantive or impeachment evidence, I would have been able to, even if it was only impeachment, I would have been able to, it would have been one of the only effective opportunities that I would have had to actually impeach this witness. It was very difficult to impeach him with his written statement being denied completely.
Okay.
Well, I got to 2 out of 4 of my issues. I wish I had time, maybe in my last 3 minutes, I'll say something about why I think this court date, Mr. Wilkerson being given a court date the very following week, is significant. And I think that it's an insidious problem in Shelby County that whether it's decisive in this case or just something that the court could address in its opinion, I think there's a serious problem there. But I will stop and ask the court to reverse and remand this conviction. Thank you.
Afternoon again, Your Honors. May it please the court, Brooke Kupental on behalf of the state. This court should affirm the defendant's convictions and uphold the trial court's judgments. First, the trial court had properly denied the defendant's motion to dismiss for lack of speedy trial. The primary reason throughout all of the trial date resets, in part obviously due to COVID, but after COVID, it was involving Williams' competency. During an extended time, and I don't have the exact date of when he entered federal custody, but he was within federal custody under the presumption that he would become competent after he left this training. And the defendant cannot demonstrate any prejudice by the delay. And the court has to consider all of the Barker factors when analyzing the trial court's decision. And ultimately, the strongest factor in terms of prejudice is whether it impaired the defense. And the trial court had found that the only possible impairment was the fact that the officer that had the body camera footage had passed away during this time. But the defendant admitted that the footage was eventually entered into evidence and agreed that it was available, but failed to explain how the officer's lack of presence or lack of testimony would have ultimately helped her defense. And in terms of her claims about anxiety and separation from her children, there was absolutely no proof on the record outside of attorney's arguments when discussing her allegations of different mental health afflictions. And we do need that evidence on the record. And the defendant does cite to a federal precedent regarding this factor, and certainly it's persuasive, but not ultimately controlling for this court. Additionally, the trial court found that the delay was necessary for fair and effective prosecution of this case. Obviously, the COVID-19 pandemic, this was a 2-year delay in all jury trials. And again, Williams' competency. The state had found that it would have been essential to try these two together. Williams was the co-defendant that ultimately shot and killed the victim, Mr. Cowley, in this case. And the state had found it necessary to try them together. And the court ultimately set a final date. It said, this is the date that we're going to have trial. We are no longer going to wait for Williams' competency. this is when we're going to do it, whether or not he's going to become competent. And that's ultimately what happened in this case, and the trial court severed the co-defendants. And ultimately, the trial court was trying to ride this line of respecting the state's wishes and trying the case of how it would like to, but also respecting the defendant's right to a speedy trial. And the reason, partially the reason why the trial court had delayed it out another 5 months was there was a huge backlog of cases due to COVID. And trying to work through scheduling was a bit of a challenge here. So it wasn't just the conflict of the prosecutor. And again, we had a new prosecutor after the first set trial date. There was a change in lead prosecutors. And with all of these factors, the court ultimately found that there was no bureaucratic indifference or negligence. In addition to, there was also delay caused by the defendant. Before the pandemic, the defendant had requested several resets to conduct additional investigations. So it wasn't just the state alone requesting these resets. And at one of the, I believe it was the September 19th hearing, Williams' attorney actually discussed how she couldn't get in contact with Williams, and had specifically requested that the trial reset the trial date for after his final federal competency hearing. So we have many different factors and reasons why, legitimate reasons why the delay had happened. And even though the more than 1 year delay is presumptively prejudicial when looking at all of these factors together, the trial court had properly denied the motion. And while we are on de novo review, deference is given to the trial court's fact findings, and it did make pretty detailed findings regarding each of these factors. In terms of the Ferguson issue, the trial court also properly denied the motion for the Ferguson jury instruction. The evidence just did not implicate Ferguson here. The defendant just simply failed to show that the audio recording existed. We have the police report. We have Sergeant West, who stated in her police report that she had put a recorder in her pocket. But after that, we don't know what happened. We don't know if the recorder had failed to record, if the officer had perhaps, if it failed to get a separate recorder. We don't have that proof. And for that reason, the court had found that there was no negligence in the state preserving this evidence, because the trial court found that it simply didn't exist. Now, Wilkerson had testified that Sergeant Starks had typed his statement in front of him while he told his story. And so that would make sense why Sergeant West had stated that there was a transcription of his statement. If he was typing out in his voice, it would make sense that it would be in his voice. And again, we're on de novo review, but we do give deference to the trial court's fact findings here. And additionally, in terms of the impeachment of Wilkerson, the value itself wasn't apparent because we had this statement and the defendant was able to impeach to some degree. Was able to impeach Wilkerson with this statement. The written statement contained several inconsistencies as compared to his testimony at trial, and the defendant had relied on all these inconsistencies to impeach him. And Sergeant West testified that Wilkerson had the opportunity to not sign the statement. He had read it before he signed it, and ultimately, at trial, Wilkerson said he did not outright deny the written statement as a whole, but only to the extent that the officers had perhaps worded it differently than what he would have liked. Further, the sufficiency of the other evidence was significant, and the defendant does concede this issue, that the state had substantial evidence tying her to the crime. At the beginning of Wilkerson's interview, he immediately identified the defendant by her picture. We also have Mr. Cowley's identification. We have the defendant's fingerprints on Mr. Cowley's car, the defendant's presence at the scene, and we have a video recording of her leaving the apartment complex, and eyewitnesses who testified to seeing her kind of stand over his body before she ended up leaving, and they had a brief interaction as well. The victim had also made certain statements about how she had set him up and how, and on the body camera footage, Mr. Cowley said that the defendant knew her co-defendants. And ultimately, the trial court made a fact finding that the recording itself didn't exist, and this court is bound to give deference to that fact finding, and ultimately, the evidence doesn't preponderate against it. Finally, and I know the counsel, my friend on the other side, had briefly mentioned about the police report and the lack of incentive, but ultimately the trial court had set this date to avoid the defendant and Wilkerson from meeting in lockup. There was no interaction by Wilkerson's defense attorney or the prosecutor in setting up this court date. The court explained that there was no evidence that this was related to a plea offer, or excuse me, there was no evidence that the hearing itself was related to a plea offer, and even if it was relevant, the defendant acknowledges that the ultimate probative value was limited there. And it would have likely confused the jury because the defendant had intended to admit this at the end of, but after Wilkerson had testified and the defendant asked to admit it essentially as substantive evidence without coming through any witness. And unless the court has further questions, the state would rely on its brief for the remaining issues and ask that this court affirm. Thank you.
Thank you.
With respect to the prejudice element of the speedy trial analysis, I don't think it's hard to, state suggests we need proof of impairment, that staying in jail longer after you'd been told that you had a trial date, after you'd been told that you had a second trial date, that would impair your ability to testify. I think that's self-evident. The trial court, the state says that well, I didn't get into this bias issue at all about the about the court date for Travis Wilkerson being the following week. My contention to the trial court was that what the state does in Shelby County is they say, you testify for us, we'll give you a court date the week after you testify, and we'll give you a heck of a deal. Several attorneys testified essentially to that process in the motion for new trial hearing. Mr. Wilkerson had his court date the following week, the following Monday. We don't know what kind of deal Mr. Wilkerson got yet. We know that the state came to court several weeks after Ms. Moore's conviction and said, Judge, please let Mr. Wilkerson out on a recognizance bond on his murder charge. That's what he got. The state in Shelby County, this is their pattern and practice. They never give someone a deal before trial. They wait until the consideration is given so that you can't cross-examine the testifying co-defendant about what his bias is effectively. The judge said that he set that trial date. That's what he said. That's what's in the trial transcript. There's no transcript of the hearing where that trial date was set. At least it hasn't been ordered yet. I think we could get it, but that's what he said. But the judge also threatened to change the trial date, or change Mr. Wilkerson's comeback to court date, push it months out so that the court jacket showing that he was coming back next week would be totally meaningless. There's serious reasons to question whether those statements about why the court date was given are credible, given the fact that the judge was willing to manipulate the record to change how it would appear to the jury. This is a experienced trial court, and the trial court also made, in considering the motions regarding lost evidence, made very concerning and confusing rulings where he found that there was no negligence in losing evidence, even though negligence is presumed when evidence is lost, and the detective conceded that he at least lost the video recording from inside of the BP station. And the judge held that there was, in that ruling, unnecessarily saying, he had already said, you haven't even proved the evidence existed. Then he said, you haven't proved it's material evidence. You haven't proved that the recording of the co-defendant's initial statement to the police is material evidence. That's not calling balls and strikes. The case law is clear about what materiality is, and there just can't be any question about whether that evidence would have been material. Thank you.
Thank you.
Thank you, counsel. Thank you, General. Well argued, well briefed, and I believe that concludes our docket.
All right.